Hey everybody, and welcome back to the Strategic Money Mindset. I'm your host Chase Borganelli with my co-host Rob Hughes, and today we're going to be covering a topic that everybody needs to hear about. It's estate planning.
That's right, Chase. Estate planning isn't just for the wealthy. It's about making sure your family, your kids, your future are protected, and it's much more than a will, which you'll learn about today. We're going to talk about trust, powers of attorney, healthcare directives, and maybe even ladybird deeds. Ladybird deeds. All tools that are used to protect your assets and keep your family out of probate, which you will learn a lot about today.
Exactly. So today we brought in someone who lives and breathes this topic. Our guest today is Tiffany Sullivan. She is an estate planning attorney who's helped countless families and individuals implement all of these strategies, and she's going to help us cut through the confusion and explain how to protect your assets, avoid probate, and make sure that your family and your loved ones are taken care of. So Tiffany, welcome to the show.
Thank you. I'm happy to be here. As you said, my name is Tiffany Sullivan. I've been doing estate planning law for over 20 years. I started in 2003. So I do estate planning, which is, of course, your wills, your trusts, powers of attorney, ladybird deeds, which we will talk about because they're so important, especially if you have property in Florida. And I also do business planning. So I set up LLCs, corporations, and things like that. And so I'm excited to be here today and share with you all.
Yeah, thank you for being here. Well, Tiffany, let's kick things off, and let's start off kind of simple and answer just kind of a basic question here. But what does estate planning really mean? A lot of people think that's just, hey, I got a will, but it's much more than that, correct?
Absolutely. So obviously, I want everyone to have a will or a trust, depending on what your situation is, and that's super important, but it's so much more than that. So a lot of times people don't understand that their entire estate is not just the things they want to pass on, it's all of their accounts, their bank accounts, their money market accounts, their 401ks, their IRAs. And so literally everything that you own and have access to makes up your estate. And some things I can help you with a will or a trust, and some things you're going to have to handle on your own. Meaning, I'll tell you need to name beneficiaries, you need to speak with a financial advisor, that kind of thing.
Right.
So estate planning is so much more than just having a will, and so I try to make sure that everybody that meets with me knows that. Like, I want to do the will, I want to do the trust, I want to make sure those things are handled, but you also have all these other things, and so that's what it is, like the whole picture.
Awesome. Okay, so I know we just kind of mentioned a little bit here, wills and trusts. Can you kind of explain the difference for everybody?
Yeah, so 9 times out of 10, a will is going to be subject to probate. 9 times out of 10, a trust is not subject to probate. And then depending on where you live and where your property is located, especially when I say property, I mean dirt, where your dirt is, whether it be a house, a mobile home, I don't care what it is, but if you have dirt in a state, that is the thing that I'm looking at, because those are the things that are always going to be subject to probate unless I have a different avenue for making sure that it passes the way you want to outside of probate. And what I mean by that is, you brought up the ladybird deed. So in Florida, I'm licensed in Florida and Alabama. Alabama does not have this tool available. So if you have dirt in Alabama, we're almost always going to have to do a trust in order to make sure that your dirt passes outside of probate.
Gotcha.
In Florida, we have what's called the ladybird deed. That is the lingo for it. The legal term is enhanced life estate deed. And so if you want to transfer your dirt, your real property in Florida, we can do an enhanced life estate deed. And what that says is, when I pass away, if somebody records a death certificate, these people get that property automatically. And you can do that in 49 other states. Again, I don't like to make fun of Louisiana, but I just don't know what happens over there. Like, it's a different planet.
I don't think anybody does.
Right, it's a different world. But in 49 of the 50 states, you can do what's called a life estate deed, not enhanced. Life estate deed, beneficiary deed, and that says that when I pass away, if somebody records this death certificate, that person or these people named on this deed get my property. The burden in 44 of the 50 states is that if somebody does that and they want to take a HELOC, or they want to get a second mortgage, or they want to sell the property, every person they named in that life estate deed has to sign off and give them permission to handle their property.
Oh, wow.
Right. Florida has what we call enhanced. And the enhanced life estate deed says this: I can do whatever I want to with my property during my lifetime. I can sell it, I can mortgage it, I can HELOC it, whatever I want. But the minute I pass away, the people that I named on that deed get it when they record a death certificate. And so that's the beauty of the enhanced life estate or the Ladybird deed. And so I use that a lot in my estate planning for people who have dirt in Florida. It's Florida, Texas, West Virginia, and 2 states up north.
There's a couple other ones.
Right, but I don't even, there are 5. But Florida's one of them, I know that for sure. And I use it a lot to help people do their estate plans.
Yeah, yeah. So I can vouch for Tiffany on that. I've seen her work her magic, and she knows what she's talking about.
Yeah, and I think the overall message with the Ladybird deed, even the trust and the wills, is stay out of probate, right? Because it gets messy. Tell us a little bit about, so, you know, when I think about probate, and I have had clients go through it, and it is a messy process. I actually got a client right now going through it, and we're waiting on the house and all that stuff to clear where they can go get it sold, and just, it's turned a couple of months long process into 7 or 8, 9, maybe even a year now.
Oh, wow.
With everything going back and forth. Give us a little bit of, what do you typically see from a timeline standpoint, and then on the back end of that, what's the cost of some of that, how that can affect you?
Yeah,
Because that's important.
It is. So people ask me all the time, well, if I want to help my beneficiaries avoid probate, what is it going to cost me versus what it would cost them if they have to go through probate? And 9 times out of 10, we're talking about dollars, but I also have to make them realize it's not just dollars. Because if you have a loved one going through probate, they are already going through the loss. They've lost somebody they love, and now they're having to handle the business of the person that they love.
Mm-hmm.
And so it's so much more than just dollars, but comparable dollars versus what you're going to pay to make sure that you protect your entire estate from probate versus going through probate is minimal. If you pay me to do a trust or a Ladybird deed or whatever it is that you need to make sure that your beneficiaries can just inherit from you and not have to go through that process, is going to be pennies on the dollar compared to probate, the process. And then the timeline is who knows? And it really depends on how quickly that particular judge who handles that case is going to process it. And so I can tell you 100% that in Florida, Alabama's the same, is that you're going to have a period where you have to notify all potential beneficiaries. And who you think is a beneficiary is not what Florida law says or Alabama law says is a beneficiary. There are statutes that say you have to notify all of these people in this family tree. And so letters have to actually be sent. You have to give them a period of time to say, yes, I am a part of that family, and yes, I do want to claim whatever I'm entitled to. That happens. And that's not even that bad. The worst part is that you have to notify creditors. And the way we do it in Florida is we do 3 weeks notice in a local newspaper to creditors of this person who passed away. If you have any debt that is owed to you from this person that passed away, now is your time to file this notice in the court. There are companies and people who literally make their living watching those notices. They know when the notices come out every single week. They know how much to file their claim for, where it just makes enough sense for them to make money to do it, and doesn't make enough sense for the personal representative or the executor of that will to fight it. So in order to fight that claim of debt, there has to be a hearing before the judge. That costs money. You have to hire an attorney. You have to have a person in place to represent you for that claim. The person who knows whether or not that debt is owed is now deceased. Yeah, and so 9 times out of 10, the person that is the executor or personal representative, because those are interchangeable terms, the person handling the estate says, it doesn't make sense for me to fight it, I'll write a check to make it go away. And that's how those people and those individuals make money.
Because that could drag it out even longer.
Oh,
right?
it does, because yes, and that is the shame of probate, is that everybody else gets paid, every other claim gets paid, everything gets settled before the actual people named in the will get what is supposed to be theirs. So everything else gets settled first before the people who the person that passed away wanted to have their estate gets their share.
Oh, wow. I mean, I can't imagine, they're already going through a grieving process, loss of a loved one, and this just tacks on to it.
Yes.
So who's in the frame of mind to really fight it,
Right.
9 times out of 10 they're not, and
So-
they write a check, and they just make it just dwindles. The actual quote-unquote estate that's supposed to pass to the people that that person loved and wanted to have their things dwindles.
So this is, I mean, not only just a terrible legal process to go through, but it's expensive, and it's
Timely.
public.
Yeah.
It's stressful, you
Yeah,
know?
absolutely.
Oh, wow, jeez.
Okay, so when I meet with an individual or a family, whatever it is, I always look at, the first thing I look at is, are there minor children? Because that is always gonna be my main concern, and I'll tell you why later, we'll get to that. And the second thing I look at is, how do I keep this person or this couple out of probate? Because I know for sure that's never gonna be a good pay for anybody.
So let's just kind of cover it here. So, with probate, your family is looking at, like, Robbie talked about what should have been a quick thing is now going on 6.
Yeah, I think we're in month 8. I was sitting there thinking back. I think we're in the 8th month of that home and land transfer.
Yeah, so we're looking at like 6 to 24
system
to a year.
Yeah.
I mean, but not only, you're paying thousands in legal fees, most likely dealing with court dates, having your entire estate posted to the public.
Yeah.
So let's kind of switch gears and see what happens without probate. So now your assets move smoothly on to the beneficiaries, often within like maybe a week or so, like that, depending, I guess, on which judge you get, and then it moves on directly to your loved ones. So no court delays, no expensive fees, no anything like that, and no public exposure. So you can just go through the grieving process.
Yeah. So, and I think the overall message with that is probate makes things harder.
Definitely,
Having
and
your
expensive.
estate planning in place makes things easier. Then
Yeah.
tack on the expense side of it, right? And so, that's why we encourage most, if not all, of our clients to make sure that's one of when I'm doing my discovery work with my clients, that's one of my questions is, do you have a will? Do you have a trust? Because if they don't, that's where the recommendation comes from, right?
Yeah.
And so that's not my expertise. I'm going to stay in my lane as an advisor,
Right.
but it is too important. This is such an important part of the process. And why would we go build all this wealth and these assets and things that we're going to do together as a client advisor relationship if there's not that protection piece on the back?
Oh, yeah.
It doesn't make sense.
Absolutely,
And
because all that work just
it's
for
just for
nothing.
naught. So
Yeah.
or it's not going to do what we think it's going to do
Right.
down the road. So
Also, I want to say one other thing, because this happened twice this week. I met with a client on Monday, I met with a client this morning, where they thought they were doing a ladybird deed. They thought, and so please, for the love of Jesus, do not go prepare your own deed thinking that it's so worth hiring an attorney. It doesn't have to be me. I would love to help you, but it doesn't have to be me. An attorney that understands what the language in that deed needs to say. Because I've seen 2 deeds this week where they thought they were doing the right thing, but they didn't have survivorship language in it. And when that happens, and so it's both times it was a parent and a child named on the deed, and the parent passed away, but there was no survivorship language. That means that the parent's quote-unquote ownership interest must be probated. So they thought they were doing the right thing. They prepared the deed. They recorded the deed. It was not the language that needed to be in the deed.
Oh, wow.
So just don't.
So let me ask you this. So I know a lot of attorneys practice kind of general law. So in this instance, I know you are strictly estate planning. So I, based on, personal experience here as well, I would go to an estate planning attorney because just for that instance, the general attorney might not catch that or might not put that in there. So please, just like Tiffany is saying, go to an attorney that understands the language specifically an estate planning attorney.
Yes,
Yeah.
so true, Chase. So the one that I met with on Monday had an attorney prepare the deed at a closing title company agency.
Oh, wow.
And still, right. And so the one today, they did the deed themselves. But yeah, so I tell people all the time, listen, attorneys are very much like doctors. Like if you have a cold or an earache, you go see your general practitioner. But if you wake up and you can't walk because your foot hurts, you go see a podiatrist. If you are having headaches over and over and over, you go see somebody that deals with, head issues.
Neurologist, yeah.
Exactly. And so the same thing is true especially for attorneys, because our laws that impact the way that we handle people's legal affairs, they change every single day. It's not just when our legislator meets in the fall and makes new laws, but every single day appellate courts make decisions on cases that necessarily impact the way we handle our laws. And so you cannot possibly be a quote unquote general practice, you can, but you just need to be like very generic about the things you do. But you don't need to be a general practice attorney handling somebody's estate,
Right.
because every single day laws change. And so I have a subscription to a program that sends me updates every single day about every single appellate court that makes decisions that impacts estate planning laws in Florida and Alabama, because that's where I practice. So I know every single day, getting up, that's one of the first, I'll look at Facebook first. But one of the first things I look at,
I love the honesty.
but then I look at the case law that says, okay, this is what is impacted, this is decided yesterday, and this is going to impact your clients based on these things. And I look at that, and then I say, okay, well, do I need to contact a client based on these decisions?
Yeah.
And so I tell my clients all the time, like, if you have a major life decision that changes the way you want to distribute your estate, you contact me. If I see a change in the law that impacts your estate, I contact you.
Right.
And that's why it's important to stay in your lane. I
Yeah.
love that, stay in your lane.
Mhm.
Know what you know, do what you do, help the people that you help.
Yep, exactly. That's
Yeah.
why we have Tiffany here on the show with us today. We're staying in our lanes so you can hear it from a pro.
That's right.
Yeah, so that's really great to hear about that. So let's kind of switch gears a little bit here. Let's talk about power of attorneys and healthcare directives. So something people don't always think about, what happens if you're alive but incapacitated?
Yes, so with healthcare power of attorney, I don't want to minimize that because it is important. I want everybody to have a living will and a healthcare power of attorney. But I also know that, generally speaking, if paramedics are called to your home, they're going to do what they do. They're going to try to revive you, they're going to try to keep you safe and healthy and happy. And it's not until they get to a point where they have you stabilized, but realize that but for these machines, this person would not be carrying on life. And that's when the healthcare power of attorney comes into place. And it's still important. But I don't want people to get overwhelmed with, I gotta have that. I mean, I want everybody to have that. In my opinion, the single most important document you can have is a durable power of attorney. It gives somebody the ability to make business and financial decisions for you in the event that you can't do so for yourself. And the reason that's important is because a lot of people assume that when they're married, their spouse can make those kinds of decisions for you, and to a certain extent they can. But where they can't is when you have an account like a 401k or pre-tax, anything that you have not yet paid taxes on has to be titled to your name and your social security number. And that means your spouse cannot access those funds unless they have power of attorney to do so. And I became very aware of this with a client that we have currently going on in our office right now. She had a stroke, and physically her body is fine. Mentally, she has not come around the corner yet.
That's tough.
And so, yeah, I know it's tough. And all of her money is post-tax, already paid taxes, easily accessible to pay her medical bills, but for the fact that they're in her name. He wanted to pay her medical bills with her money because all of his money is 401k pre-tax, meaning if he goes and accesses that money,
Taxes.
Yeah.
penalties,
Mhm.
all the things. And so he just assumed because they were married, he could just go and get her money to pay her medical bills, and he can't because he doesn't have power of attorney. They've been married for 30 years.
Oh, man.
But he
Yeah.
can't access her money to pay her medical bills, so he had to pull from his 401k, which means what should have been like a $10,000 medical bill now is like close to 20 because penalties, interest, and all the
Penalties
things.
plus, yeah. Plus, and you're being taxed at your ordinary income rate, and John said
Yeah.
penalties are taxed on top of
Yeah,
that.
so in my opinion, like I tell people all the time, like obviously you wanna have a will because you wanna know that whoever's giving your things, but you're gone. You're in a better place, hopefully. You're not really worried. And then medically speaking, doctors, EMT, they're gonna do what they can do. But when it comes to actual business and financial decisions, if there is not a POA in place, nobody's gonna get to do that for you. And so that to me is a huge document. That is how I made both my children. They turned 18, they signed it.
So actually, great. Speaking of turning 18, I had a client ask recently, can they have somebody who is a minor be power of attorney or anything like that? I, of course, said no, but I said you should definitely ask Tiffany on that again because I know the answer is no, but to hear it from an actual estate planning attorney sounds better.
Yeah, so if you're under the age of 18, again, in every state except for Louisiana, because I don't know, if you're under the age of 18, you literally don't have rights.
Right.
You're your child.
You're a minor still,
Right.
yeah.
And so, but the day you turn 18, suddenly you have all the rights. And so that's why I think it's so important. Like I tell every person, anybody that is 18 years or older needs three things: a will, a durable power of attorney for business and financial decisions, and a healthcare power of attorney for purposes of making medical decisions. But if you're under the age of 18, you can't own property, you can't take care of yourself, even if you can, because I moved out when I was 16. I can take care of myself, but I couldn't legally
Right.
own anything or take care of anything.
Yeah.
So 18 and older should have those three documents: the will, the healthcare power of attorney, and the durable power of attorney.
All right, that's great to know there. Yeah, absolutely. So I have a personal question here for you. So my wife and I are actually having a baby due in like 20 days or something like that. Getting close, but who's counting? So for that instance, what should I be thinking of doing?
You definitely want to, I know that you've already done this because I've met with you, but definitely for any person that's expecting a child, like you want to meet with a person that understands estate planning laws, especially in Florida, because again, minor children cannot take care of themselves. They cannot own property. And so if you have minor children, you need to designate a guardian that's going to, one, take care of those little people.
Right.
And then you need to designate a trustee that's gonna take care of the money that you leave to take care of those little people.
Gotcha.
And sometimes that's not gonna be the same person. So for me, well, my children are now adults, so I don't have to worry about it, but when they were minors, when I first set my trust up, I was like, obviously their father is the best person he's a great dad, he's the best person to take care of their bodies
Right.
if I pass away. I didn't necessarily want to leave all of my money to him to do so, so I named my best friend as the executor or the trustee of the money that I left for them. And so sometimes the person that's going to take care of the kids is not going to be the person that's going to take care of the money.
Right.
You know, and so you want to meet with somebody who knows what they're doing, that can help you designate the person to take care of those little people, also, and take care of the money that's left for them.
That makes sense.
And I will tell you this is so important. Again, I've gone through some cases, but one of the cases I went through when I was still doing litigation was a very young couple. They were coming back from, I think, Gatlinburg. And it was a husband and wife, and they had a 4-year-old son and a 2-year-old daughter, and they were in an accident. The mom died on the scene. She was dead. Dad was in a coma for a period of time, and I think it was the mom's parents that showed up to the hospital to pick up the little people were fine. 4 and 2, they were fine. They're resilient, right?
Yeah.
I think it was mom's parents that showed up. I can't remember. It doesn't matter. The point is this: the hospital cannot release to anybody that is not named in a document. And the mom and dad had never prepared a will. They had never named guardians. And so those 2 children, one, they lost their mother. They were in a horrific accident. Dad was in a coma. They went to Child Protective Services for 3 days until a judge could look at the documents and determine the best people to take those children out of Child Protective Services. And so the reason that's so important is because some of us have really great parents on both sides, and some of us don't. I personally know that I would not want, if my little people were little people again, I would not want either of my parents showing up to get those kids in a situation like that. I would rather them go to strangers versus, and that is the reality in a lot of families.
Everyone's got different situations.
Exactly. And so the courts have taken the decision out of healthcare people, EMT people, like they don't get to decide anymore. And so unless you have documents in place that say, these are the people that I want to take care of my kids if I can't, then a judge that has never met you or your children is going to decide that. And it's often days later after a tragic accident happens.
And that leaves them in, child services for a period of time.
Yeah.
That's
Yeah.
terrible.
Yeah.
Could be a long time actually.
Yeah.
Depending on the situation.
And especially if people fight it. So if the parents that showed up really wanted to fight it, then it could be even longer, yes.
Oh, wow.
So I've got a story, and you kind of covered my question I had to you a minute ago. So I've got a son that just turned 18, month and a half, 2 months ago now. So we're living in that world of young adult who thinks he knows everything, but he's a really good kid. But we ran into a situation just a few weeks ago where he got pulled over in our neighborhood. Was going a little bit over the speed limit. It was late at night. I would say after midnight, which his curfew is at 12, so he knew he was late and was trying to get home.
On time.
I wouldn't say he was even going to get there on time. He was trying to get there without being 20 minutes
He's
late.
pulling a Ricky Bobby.
So, but long story short, he got pulled over. And when you get pulled over in a small town like I live in, just across the bay from where we're sitting today, you don't get one county sheriff. You're usually going to get
Several.
You get
the whole
squad.
department show up because they've got nothing to do. So we went through that, and it was a little bit eye-opening, a lot eye-opening for him, but a little eye-opening for mom and dad too, especially since we had just had a conversation about getting home on time and not after midnight 2 days before that, and so it was one of those told you so moments. So we had that conversation, but a little eye-opening for us because there's nothing I could do for him, and so I did go down the street. I mean, he was literally, I walked into the driveway, I could see the police cars there. So
He almost made it.
I almost made it
Right there.
He was about 500 yards from making it. So, but I jumped in my truck and I eased down there and had a conversation with the police, and they were super nice. Love our law enforcement, our brother's law enforcement. So, that's. We definitely appreciate, and we appreciate what they did with him.
Yeah.
So, they did run him through the gamut, and he did have to blow on the old breathalyzer thing there as well. And they were super gracious, and they gave him a warning. And and a lot of that may have been a conversation I had with him about, hey, I pay for the truck, I pay for the insurance, please don't
Being a
do
good
this.
dad.
So doing the dad thing, right? And so, but it is very eye-opening. And had he gotten arrested, had things gone differently, which I won't say they easily would have. I've got a wonderful, both of my boys are very good kids and have always been, and been blessed there. But it was very eye-opening because I do have clients, and their kids are friends with my son, and so there are definitely challenges there at times with things. And again, they are young adults; their brains are not fully formed, as we know, and they do make dumb decisions at times. And so we have to be prepared for those moments and make sure. And so that was, we literally did a run through of this podcast not a few days after that, and it is definitely something I've got to get planned and sit down, and we've got to get those documents done sooner than later because it is important. And that was one of those moments where things could have gone south, and
Yeah.
you know, not a lot I can do other than calling Tiffany at 2:00 in the morning saying, "Hey, what's
Yeah,
up?"
mine
I know, right?
My-
So-
She's not a 24/7 service.
I
That's
literally, I love my sleep so much, and I'm in bed by 8 every time. I'm the old lady, I promise.
Yeah,
My
I'm
phone
old man,
rings
so
I'm right
between
there.
8 p.m. and 5 a.m. My phone will only ring if my children call me.
yeah, yeah.
It's turned off for
Well,
everything else.
and it goes back to, you know, Tiffany's an expert in this field. My office is actually inside of another attorney's office, but he does criminal law and some of these things. So he probably would have been my guy to go to because, and he practices, most of his practices in Milton as well. So he, or in my hometown there, but he, you know, he knows everyone.
Yeah.
Yeah.
So he can make the phone calls and you know, help us out as needed. But, and that's his expertise there. So, but
I will tell you this, in response to the story you just told, I will go back to what I said before, is that every person over the age of 18, so if you have children, especially if you have children that have turned 18, power of attorney is so important. A will is important too, but a power of attorney is super important. And again, the good Lord has given me stories. And so one of my stories is this. One of the last things I did as an attorney, in addition to that story I told you about the young couple that was in the accident, one of the last cases I handled in litigation was an 18-year-old boy. And he was in an automobile accident with the driver of an 18-wheeler truck. And he was in a coma for like 5 days. He ultimately passed away, the 18-year-old did. The driver of the 18-wheeler was drunk at the time of the accident. The company that owned the truck he was driving knew of his history of driving drunk, had knowledge that he did this on a regular basis. And so the 18-year-old's estate, because he passed away ultimately, his estate sued the company, as they should.
Right.
And ultimately, they got a judgment of $2.5 million. The dad of that 18-year-old kid got half of that $2.5 million, but the dad had never laid eyes on that kid. Never had a relationship with him, never paid child support. Literally, he helped create the child, and that was it. But because he helped create the child, he got half of that. And that's bad enough. The other part of it that like makes me sick, and like to this day, even though I don't do litigation anymore, makes me sick, is that kid, because he didn't have a will, obviously, dad gets half. That's the way the law works. But he didn't have powers of attorney in place. And so at any point in time, dad could have showed up to the hospital and said, hey, quote unquote, pull the plug. Because he's the dad, and the kid didn't have powers of attorney in place to say, no, my mom raised me. My mom knows my heart, my desires. My mom can make decisions because he never signed those documents. Because as an 18-year-old, why would you? As a general rule, 18-year-olds, you don't have anything, so you don't sign documents.
if I remember the story, he didn't even know that the child had passed away. He saw it in the newspaper or something like that.
Yes.
That just makes it that much worse.
Yes.
It was.
And so a lot of times people say, well, why does an 18-year-old need these documents? And I get it, that's extreme.
Yeah.
But I've seen the extreme, and I understand why it matters.
Well, I'll even say when my grandfather passed away 15, 16 years ago, maybe 2003 timeframe, so
Yeah, more than that.
almost
22
22
years
years
ago.
ago.
We're getting old. We're getting old.
You call yourself
So 22 years ago, wow, it doesn't feel that long. But I watched my dad. He was the trustee of the estate, and he did have dual power of attorneys and all that stuff in place. He still struggled working with the bank, and my grandfather, he had money, I think, in every bank in Santa Rosa County. If they had a CD that was
He was
getting
on
a
it.
decent
He was
rate,
on it.
he would drive for 0.5%. He was going to drive across town to get that thing. And so it was months and months and months, and paperwork, battle almost every single time going into these institutions to get that money. And so, and it was waiting games because the CDs hadn't matured. And so there was a lot to all that. But, you know, even having those documents, they do help you win in the end, but it still can make things difficult even so, you know.
Oh, yes. I mean, I mean, like, I think you know, key takeaway is definitely sit down with an estate planning attorney and make sure, you know, you can have a great portfolio, but do you have a plan? You know, I mean, you know, you might be making money, but is that money gonna do what you want it to do in the instance that, you know, something happens to you? You know, so definitely this is, you know, if anything, hopefully it's very eye-opening for every listener to hear this and really make, you know, a call to action to take the next steps and make sure that everything is in order for them.
Yeah, I will say this, again, I'm not gonna say I'm the only estate planning attorney that knows what they're doing, because I know there are plenty out there.
Come on now.
But for real, make sure that you get with an attorney that knows what they're doing. The other thing is like, whenever I meet with a client and they leave me with their documents in their hand, they leave with a cover letter that says how to handle those accounts. You know, those 401ks, those IRAs, those CDs or whatever, because those are what we call self-governing.
Yeah.
Your will doesn't control those unless you fail to name a beneficiary. So I tell my clients all the time, like, make sure, here's a list of things that you need to make sure that you handle even after you leave my office.
Yeah.
And for goodness sakes, if you divorced a long time ago and your ex-wife is still the beneficiary on your life insurance policy, just know she's not sending the check to your new wife. So make sure you take care of those things.
Yeah.
So I don't just prepare a will. I don't just prepare a power of attorney. Like, I make sure that my client knows leaving my office, these are the things that you need to, these are the boxes. This is your homework. Check the box.
Yeah.
Take care of it.
And I've got a client with not the divorce thing, but the comment before, husband had a 401k and a life insurance policy through the company he worked with. Unfortunately passed away in his mid-50s one evening and from a health event unexpectedly.
Yeah.
Guy was good health, all that stuff, just a freak kind of accident type thing. But all of his other benefits that he had, and old 401ks, IRAs, and all those things, some of those I had already taken possession of through the firm here. Some of those we hadn't yet, but in that particular case, no beneficiary. He had paying for life insurance, never designated a beneficiary, which I don't know how you get through the company website.
So angry.
The company website with that, and then the 401k that he had, again, no beneficiary, and so we went round and round and round with the company on that. Finally, did get everything moved over, but it was a lot of work that we did to get
Yeah,
those
if you are investing in a 401k or you're buying a life insurance policy and the person you're working with doesn't ask you who your beneficiary is,
Run.
just walk out the door.
Yeah, exactly.
And go somewhere else, because
Exactly.
we all know as professionals.
I don't even know how you skip those questions.
Well, you
I
can't.
don't either, but it happens all the time, Rob.
I've
Yeah.
seen. I've seen.
If
That's
you're-
not the only time I've seen that. I mean, that was just one that was
Yeah.
your.
Yeah.
Yeah, that's the same instance with the client. You know, we worked with her together. Her husband didn't put her on anything, and bless her, it is an ongoing process still to this day. But it is so important that you name your beneficiaries, and if you're working with somebody
That doesn't ask the questions,
exactly,
go somewhere else.
Yeah.
I got people.
Our annual reviews. That's part of my interview
Yeah.
process.
Yeah.
401ks, all that.
Making
I want to
sure
see
that-
everything,
Yeah.
and then we're going to do beneficiary checks on
Making
all
sure
of this
nothing's
stuff.
changed.
So anything they got with me, I can pull up. But
yeah.
company stuff, we're logging in. I will make them almost sit in front of me and log in. So, a lot of our meetings are on Zoom
Yeah,
now.
at the end of the
So
day, we are in the people business.
Yeah.
We love people. We want to help people. We want to make transitions as easy as possible.
Yeah.
That's what we do,
Oh yeah.
and that's the reason I love,
We got a
what we
great
do
group.
together.
Yeah,
Yeah,
all the
it's-
pieces fit together.
absolutely.
So, real quick before we wrap up here, Tiffany, can you kind of explain to everybody your process on if somebody wants to meet with you or get in contact with you?
Yeah, for sure. So all of my consultations are complimentary. I learned very early to not say free because that makes it sound like it's not valuable, but I do complimentary consultations. And all I ask is I have a questionnaire that I send out, whether it comes from me or whoever's booking the appointment for me. All I ask is that you fill up the questionnaire and bring it with you when you come to that consultation, or send it to me in advance. And then we sit down and we look at everything. And I tell you, okay, this is what I think that you need to do. And then after we leave that appointment, I'll send you an email. So again, I don't know, Alabama just like lets me do what I want. Florida's very, very strict. And so I have to have a representation agreement. It doesn't have to be in writing. So I'll send you an email that says, hey, based on what we talked about today and based on this questionnaire that you filled out, this is what I recommend, this is what it's gonna cost. I will tell you that I have the benefit of offering very reduced rates compared to other attorneys in this town because I work inside of a retirement planning company that doesn't charge me overhead. So I get to actually just meet with clients and just tell them what they need and charge them a fair marketable value. So I'll send an email that says this is what I recommend, this is what I'm gonna charge. You say yes, I go to work, I prepare the documents.
That's great.
We review the documents, and when they're exactly the way you want them, we bring you in one more time, you sign them, we do the notaries, the signatures, the witnesses, and you walk out with your originals. I email you the copies.
And that's why we love working with you, Tiffany. So
Mm-hmm.
real quick, if you would, just give your email address, so for listeners, if they want to reach out to you, you know, they can contact you.
Yeah, so first, my phone is 850-380-8838, and my email is tsullivan, SULLIVAN, at realsolutions, plural, solutions.biz, B-I-Z.
Awesome, great, thank you so much. I just want to say, Tiffany, really appreciate you coming on to the show and going over all this. This has been eye-opening, and I hope everyone listening has definitely learned something today. So with that, Rob, do you have anything else you want to add?
This has been awesome. I love this episode, so I've been looking forward to doing it again. But yeah, it's been great, and great information here, Tiffany.
Yeah, just thank you again, Tiffany.
Absolutely.
Yeah.
Next time, let's talk about businesses and LLCs and corporations. We'll do that in
All right,
the
well,
future.
there's a future episode for you folks.
Looking forward to it.
Yeah.
Absolutely.
All right, everybody. Well,
Yep.
thank you for joining us.
Till next time, stay strategic with your money.
There you go. Take care.